Yeah.
अच्छा क्या बना दे तुला बच्चे 12 minutes, okay.
Today's story, and there's lots of good news that happens in this great country of ours that often doesn't get covered on prime time. Here's one today. Nagpur University graduates are first Thanks very much, Rahul, for joining us. First of all, many congratulations. Obviously, most people now are have. What is the biggest challenge of the last
So, good evening, all of you. We'll be starting with the session till the time Mr. Danlami BASHARU joins us. Honorable Justice Dr. Chandrachud, Judge, Supreme Court of India. Mr. Danlami BASHARU, Executive Director of Anglo-Nigerian Welfare Association for the Blind. Chair, UN Committee on the Rights of Persons with Disabilities. Ms. Vaijayanti Joshi, Director, Academics and Administration, ILS Law College. Dr. Sanjay Jain, Principal, ILS Law College, Pune. Members of General Council, General Body of Indian Law Society, dignitaries present, dear colleagues, students and participants. Wish you all a very good evening, good morning and good afternoon, depending on which part of the world you are joining from. To begin with, instead of the keynote, because it's taking little time for Mr. Danlami to join, I would request Dr. Sanjay Jain sir to begin with his welcome and introductory address.
Thank you, Sati Madam. Now, Honorable Secretary, Indian Law Society and Director, Administration and Academics, Joshi Madam, Justice D.Y. Chandrachud, my colleagues, all other invited guests, students, ladies and gentlemen, and particularly I would like to refer to my mentor and my friend, Professor Anna Lawson, who is also here. Really, this is a mesmerizing moment for me, personally, because I have not seen seldom as many as 3 Supreme Court judges giving their very precious time to the cause of the empowerment of the disabled. And I think this is a good sign, and this goes to show that gone are the days when PWDs were simply looked down. Gone are the days when look upon PWDs as mere objects of charity. So, sir, I really wholeheartedly thank you, and I also thank the institution of Supreme Court for having shown the much needed sensitivity. However, I'm not going to pull my punches, and I'm going to be candid about few things today, because I'm not going to get opportunity to speak my mind to Justice Chandrachud again and again. So, sir, let me begin my speech today. Let me share my thoughts today on a very, very important note. Recently, International Disability Alliance, International Commission of Jurists, and UNDP has rolled out a very important document called International Principles and Guidelines on Access to Justice. This particular document was released just few days ago, and when I started reading this document, really I became very happy, and it really excited me. I was very happy to see that historically entrenched notion of access to justice, confining it as far as confining it at the most to making the courts built environment accessible, or talking about accessibility in documentation, etc. But I think this principle, this document which has recently been rolled out, is a revolutionary document in many ways. And Principle 7, which I am trying to present, particularly I seek indulgence of Justice D.Y. Chandrachud to Principle 7, because Principle 7 of this document very categorically now states that entire administration of justice dimension now has to be inclusive, and every aspect of administration of justice has to be now opened and enabled to enable the people with disabilities to participate. And of course, one of the dimensions of the administration of justice is judging. And particularly if I were to attract attention and seek indulgence of Honorable Justice Chandrachud, I would attract his attention to guideline 1 of Principle 7, which categorically mention inter alia that disabled persons must also be facilitated to become judges if they aspire to have that career. And I hope that in the light of Visakha mandate, and in the light of our jurisprudence, which also takes cognizance of incremental development of international law, it also takes cognizance of soft law. I'm pretty sure that these principles will find their due mention in some judgment of the Supreme Court very soon, and I think very soon you'd have some judgment of the Supreme Court opening the doors of the judiciary to the blind people. And I think this has come as a blessing in disguise. This particularly these guidelines and these principles have come as a blessing in disguise. So therefore, first come first, I wanted to talk about these principles. And I think when I'm going to roll out the Pune agenda on the back of this summit, we are going to emphasize rather, with the help of our other collaborators, how we make best possible use of these principles. Now, second important thing which I want to emphasize is this, that historically people with disability have been undermined. Historically and sociologically, we have been overlooked and neutralized. But what about history? You look at Thomas Alva Edison, or you look at Albert Einstein, or if you look at John Austin, or if I were to talk about Indian Nani Palkhiwala, who used to stammer during his early days. And when I was reading about him, I came to know that Bombay University refused to hire him because of his stammering. And thank God, otherwise we would have lost a brilliant lawyer, and he made stammers so many stalwarts when he started practice. So I personally believe that there is nothing in this world which cannot be achieved if you have a willpower, and if you have the tenacity, you can claw back from any adverse situation. I believe that with the support of angels like Justice Chandrachud and other fellow judges from Supreme Court, and with the support of progressive civil society, we are going to have optimistic times for persons with disabilities. Before I conclude, brief in time, sir. In last 3 days, we had wonderful sessions. The tone was set by a very appropriate keynote by Professor Maria when she talked about accessibility. And then we had a wonderful session on by disability academicians and likes of Professor Lawson, Professor Michael Stein, and others. They participated in the deliberations. And the important takeaway of that session was to evolve disability legal studies and to persuade the non-disabled to engage with disabled scholars, to provide mainstream exposure to the disability legal studies. Then in the next session, which was dedicated to disabled lawyers, and in that session, likes of Professor S.K. Rongta, Laura Hogue, and others, it was emphasized that, because people with disability are themselves being the targets of the discrimination, they are empathetic. They know the difficulties of the people, and therefore, if they are in the position of judges, they would be able to appreciate the difficulties of the victims. They would appreciate the problems of the litigants, and it was also emphasized that you have to work hard. Law is a field where if you have a desire and if you have the tenacity, you can do very well. And it was lamented that very few people with disabilities really adopt or go for the legal careers. And it was emphasized that we should encourage more and more disabled people to take the career of law. Today's sessions were exceptionally good. We had a wonderful panel of disabled judges but the tone was set for this panel to know by Justice Sikri to emphasize on inclusion, equality, and dignity. And then we had experiential presentations by Justice Goel, Justice Richard Bernstein, and Justice Jaggi from India. And we also had a very brilliant, crisp video by Zach Yakub, in which he lamented why people, why mainstream non-disabled community tend to think that even disabled even do not have the ability to think, leave alone adjudicate. Sir, then we had a very wonderful fireside chat with Haben Gorma, a first deaf-blind law graduate from Harvard University. And indeed, I personally was tremendously inspired from her achievements and her extraordinary presentation. So, sir, this is the sum and substance of the summit. Of course, when we roll out the agenda, you will have further details about the same. So with this, I conclude my short speech. Thank you very much.
Thank you, sir, for that crisp conclusion of the long 3-day session. May I request Advocate Rahul Bajaj now to address his introductory remarks.
Thanks very much, Swati ma'am. Can you hear me clearly?
Yes.
Yes. So, yes. Thank you very much, Justice Chandrachud, Professor Jain, members of the Executive Council, ladies and gentlemen. Thanks very much for being here today. It's been such an honor to put together this summit. And Professor Jain has detailed the ways in which we've been able to foster, as was our goal, a well-considered dialogue on what it is that we can do to create a more enabling environment for legal professionals with disabilities. In my brief remarks today, I would just like to talk a little bit about the book that we will be launching in some time, which is called It Can Be Done, the IDAP interview series. So I would just like to talk about what it is that led us to make that book and what we hope to achieve out of it. When I was a law student 4-5 years ago and looked out and approached law firms and other employers in the legal profession in the search for internships, I often realized that they knew precious little about what concretely it took to accommodate a person with a disability in their organization. And what this meant was that they would construct out of whole cloth the notions about what kind of accommodations one would need, and then themselves conclude that they had neither the resources nor the wherewithal to be able to sort of make me fit within their organization. And it was from that string of experiences and from what I heard from other visually impaired and other disabled law students across the country also, that the conviction was born to do whatever little I could to help change that state of affairs. And this book is a step in that direction. Now, while many challenges that lawyers with disabilities face are infrastructural, some are simply attitudinal, stemming from nothing but a lack of awareness about what a lawyer with a disability, when provided the appropriate support, can do. And in this book, we try to address these attitudinal barriers by sharing actionable insight that have been deployed by 21 legal professionals who we interviewed from 6 countries across 3 continents. We covered such countries as India, Israel, the US, South Africa, Canada. And I would also like to say that the aim was to foster dialogue, break stereotypes, and open new avenues for lawyers with disabilities in India and beyond. I hope that these stories that you will read in the book, and you can purchase it on Amazon Kindle, Professor Jain will share the link in the chat box here, that they will move you, make you question your assumptions, and transform you into enlightened allies for the disabled people around you. And as you applaud these stories of grit and determination of the interviewees, I would also urge you to pause and reflect. Reflect on what it is that made it so hard for these people to succeed in the first place, and what we can do to reverse that state of affairs, so that stories of this nature become so ubiquitous that we no longer have to celebrate them this way. Thanks very much. That's all I wanted to say.
Thanks a lot, Rahul. So, Jen sir and Rahul, both of yours introduction and coming up of the events reminds me of Helen Keller's quote, which has been cited in the celebrated judgment of Jija Ghosh versus Union of India. I quote her: "Some people see a closed door and turn away. Others see a closed door, try the knob, and if it doesn't open, they turn away. Still others see a closed door, try the knob, and if it doesn't work, they find a key, and if the key doesn't fit, they turn away. A rare few see a closed door, try the knob, if it doesn't open, and they find the key, and if it doesn't fit, they make more." Ladies and gentlemen, ILS Software since its inception is known for such key-making works. This summit is one of such key-making processes for unlocking the inclusive society. So friends, because Danlami BASHARU sir is not yet still able to join, and so we would start. And our featured program for today is book release, which is authored by Rahul Bajaj just now, which he gave an information about. I would request my colleague Professor Ashish Pawar to take over for the book release function. Ashish sir, over to you.
Hello everyone, I hope I'm audible.
Yes, sir, you are.
Yeah. So, one of the most remarkable things we do as species is we tell stories, and we love to hear them too. And no other stories can be more relevant and fulfilling than the stories of lives of our fellow beings. Stories of ups and downs, of struggles and successes, stories that give us new insights and change our perspectives and attitude to life. It Can Be Done is a collection of 21 such stories of 21 extraordinary humans and their lives. A collection of interviews of 21 disabled lawyers from 6 countries spanning 3 continents and in all spheres of legal profession, academics, advocacy, litigation, corporate, and more, where they tell us about their journey of becoming who they are today in a world that wasn't really their ally. Stories of struggle, despair, and at times disdain, and the stories of courage, perseverance, and incredible strength, all set in an almost entirely ableist world. I invite Principal Dr. Jain to say a few words about the book that we are about to release. Jain, sir. Jain, sir, over to you.
Am I audible?
Yes, sir, now you are.
Yeah. Dear friends, let me first congratulate Rahul for this very important book. I believe that this book has come at a very right time. It is more than coincidence, I think, that at a time when the international principles and guidelines on access to justice have been rolled out, we have now a kind of empirical evidence by way of this very important book. The book it documents in great details the achievements of the disabled lawyers, disabled judges, and disability academicians. Without taking much time, let me just say one or two things about the book. Let me say that if we want to enable civics, then such books, or at least some chapters from such books, must be prescribed. Along with this book, another book which I would love to prescribe is the autobiography of Haben, whom we heard just in the morning. Besides, I believe that Bar Council of India has to now take up very seriously the fact that disability legal studies is a very important domain, and with empirical evidence through this book, I don't think there is any scope for any skepticism about the empirical value of this subject. So I believe that Bar Council of India must also take cognizance of this important book. And I hope that we will produce many more such books to highlight the achievements of persons with disabilities. I think this book is a work in progress so far as implementation of Article 8 of UNCRPD, because Article 8 of UNCRPD mandates the civil society to not undermine the achievements of persons with disability, but it also mandates the disability community to ensure that they also appropriately raise awareness about their potential vis-a-vis the mainstream community. So again, I congratulate Rahul, and I would like to place on record, Rahul was telling me that two of his friends, Miss Anusha Reddy and Miss Madhvi Singh, they helped him a lot in this venture. So I would also like to applaud them and congratulate them for compiling such a brilliant. On behalf of ILS Law College and on behalf of entire disability community, I wish great luck for the success of this book. Thank you very much.
Thank you, Jain sir. May I now request Honorable Justice D.Y. Chandrachud to release the book, please.
It gives me great pleasure to release the book. And thank you for giving me this opportunity and honor.
Thank you, sir.
Indeed,
Thank you, sir.
Thank
Thank
you,
you.
sir.
Thank you so much.
From the introduction of It Can Be Done, I quote, "As you applaud the courage and grit shown by these interviewees, instead of jumping to immediate conclusions about how inspiring they are, I would like to urge you to pause and reflect. Reflect on what is it that made it so hard for them to succeed in the first place, and what each one of us can do to reverse this state of affairs." Unquote. I conclude this part of book release with the hope that through the insights that we had in the 3-day International Summit and the stories that we will read in It Can Be Done, we'll make sure we not only structure around but we fundamentally change towards our fellow beings and towards the life as a whole. Thank you. Over to you, Swati ma'am.
Thank you, Ashish sir. Thank you, Honorable Justice Chandrachud. Heartiest congratulations, Rahul. Hope we get more such books from your end in coming years. I'm happy to share that we have Mr. Danlami Umaru BASHARU, who has joined us. Welcome, Mr. BASHARU. Before handing over to Mr. Danlami, I would give a brief introduction of Mr. Danlami BASHARU. Mr. Danlami Umaru BASHARU is a chair of Committee on the Rights of Persons with Disabilities, whose term commenced in January 2015. Danlami has been country rapporteur for Uganda, Morocco, Oman, South Africa, Senegal, and Niger Republic. Danlami is a lawyer who obtained several educational degrees from the UK, including from Cambridge University, and is a fellow of Cambridge Commonwealth Institute.
Where is Biodo? I'm on it now. Can you talk? I don't know.
Don't worry. Hello?
Hello, Mr. Danlami, you are audible. You are audible.
Oh, thank you very much. I'm really sorry for all the hula baloo about this.
It's okay. We can
understand. I want to thank you very much for giving me the opportunity to make some remarks on this. The Convention on the Rights of Persons with Disabilities and its optional protocol, ARES 61106, as you know, was adopted on 13 December 2006 by the United Nations and was opened for signature on 30 March 2007. It is the first comprehensive human rights treaty of the 21st century and is the first human rights convention to be open for signature by regional integration organizations. The convention entered into force on 3 May 2008. India ratified the convention on 1st October 2007. The convention was the work of organizations of persons with disabilities, civil society organizations, and government to change attitudes and approaches to persons with disabilities. It adopted a new conception of looking at persons with disabilities as objects of charity, medical model, and social protection towards viewing persons with disabilities as subjects with rights, capable of claiming those rights and making decisions for themselves based on their free and informed consent, as well as being active members of society. Around 15% of the world's population, or estimated 1 billion people, live with disabilities. They are the world's largest minority. 80% of persons with disabilities live in developing countries, according to the United Nations Development Program. The convention is a human rights approach with a social development dimension and reaffirms that all persons with disabilities, all persons with all types of disabilities must enjoy all human rights and fundamental freedoms. According to the first article of the convention, the purpose of the present convention is to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for their inherent dignity. Thus, persons with disabilities were no longer to be observed from the realms of the charity and medical models, but to be seen as people deserving of rights. This was a completely new paradigm shift which persons with disabilities were prepared to step into. This was what made the convention the fastest negotiated human rights treaty. Making the convention real in India. India had legislation on disability before now, but with the convention in place, it was prepared to rewrite its laws to conform with the new convention. 25 years ago, India enacted the Persons with Disabilities Act 1995, enacted under Article 253 of the Constitution, which it reenacted again under the Rights of Persons with Disabilities Act 2016 to give effect to the United Nations Convention on the Rights of Persons with Disabilities and for matters connected therewith or incidental thereto. The Act provides for education, employment, creation of career-free environment, social security, affirmative action in various ways, and other areas that are necessary for the inclusion of people with disabilities in the society. Although we can say that the Persons with Disabilities Act has had some advances in the fortunes of persons with disabilities in India, there still remains a long way to go in providing necessary employment and accessibility for persons with disabilities in India. For instance, quote, though persons with disabilities constitute a significant 5 to 6% of India's population, employment needs remain unmet in spite of the People with Disabilities Act, which reserves for them 3% of government jobs. That's from the NCP-AD. India submitted its first country report to the Committee on the Rights of Persons with Disabilities in November 2015 and participated in the 22nd session of the CRPD in September 2019, which I presided over. The appearance before the committee is to tell the committee what it has done since ratification to implement the elements of the convention. I shall not bore you with everything that was discussed, but just to pick out the essential elements. We were concerned about equality and non-discrimination, women with disabilities, accessibility, education, and work and employment. We were concerned about the lack of effective redress in cases of discrimination on the basis of disability and multiple or intersecting discrimination, including gender-based discrimination against women with disabilities. The disability stereotypes, stigma, and lack of awareness about multiple and intersecting discrimination on women and girls with disabilities, particularly those with psychosocial or intellectual disabilities, and the lack of inclusion of women with disabilities in general and disability-inclusive policies. The slow progress in improving accessibility to transportation, physical environment, and information and communication to technologies. The lack of awareness and capacity building of all actors in the justice system concerning the rights of persons with disabilities, and the absence of measures to accommodate persons with disabilities as judges or other interlocutors within the judiciary. We were also concerned about the rejection from and bullying of children with disabilities, particularly children affected by leprosy in schools and cases of sexual harassment in the workplace against women with disabilities. The intention of the committee was to proffer some solutions as to how India could go about making the society better for its people with disabilities. Thus, on equality and non-discrimination, we called upon the Indian authorities to ensure access to effective legal remedies and redress, including compensation in cases of disability-based discrimination and the denial of reasonable accommodation. It was also to ensure that full and effective participation of women with disabilities in decision and policy making at all levels, particularly within the National Commission for Women and State Women's Commission. It was also to ensure accessibility requirements in public procurement legislation and policies for goods and services. It was also important that India ensures training for members of the judiciary and ensure that persons with disabilities form a large chunk of the judiciary. It was to take measures to prevent rejection, stigmatization, stigma and bullying of children with disabilities, particularly children affected by leprosy. And finally, it was to take effective measures to promote employment of persons with disabilities in the open labor market, particularly persons with disabilities from marginalized groups. Transition from principle to practice. We can say that India since 1995 has had legislation which on the face of it appears very practical, but it appears meeting the standards it set for itself has been difficult. We know that Indian judges have been very robust at reading into the letter and spirit of the cases that came before them. In spite of 3% reservation for employment, the disability groups had to resort to court action to ensure that their rights were met. Thankfully, in most cases, the outcome was positive. For example, in 2003, when two persons with disabilities who were qualified on merit for Indian Administrative Service IAS were relegated to Indian Information Service SIIS, NCP, PEDP, and Disabled Rights Group DRG launched a campaign against the blatant discrimination, which led to the then Prime Minister to intervene and resolve the issue. Another case filed before the Delhi High Court ruled that 3% of the total strength of employees in any government establishment should be persons with disabilities. Further, in another case in 2014, the Supreme Court ruled that 3% reservation for disabled candidates are not only at the stage of their appointments, but also for departmental promotions. the court held that the center, states, and union territories were obligated to implement the rules of reservation for this class in the matters of appointment, selection, direct recruitment, deputation, and also for promotions. However, given these landmark cases, we continue to note the infringements of the law. Why should this be so? Is it that the judges are not accrediting themselves very well? We note infringements against women and girls, for example. A small 2004 survey in Orissa, India, found that virtually all of the women and girls with disabilities were beaten at home. 25% of women with intellectual disabilities had been raped, and 6% of women with disabilities had been possibly sterilized. We also note that the private sector proves rather difficult to penetrate. In my opinion, I believe all laws that are passed in the land are for the benefit of the generality of the persons in the land. It applies to all persons, regardless of their status. Government needs to provide incentive to the private sector to ensure that they employ persons with disabilities and make it difficult for them to opt out of legislations. It should be the job of the private sector to ensure that as many persons with disabilities as possible are given jobs under their employ. What is most needed is creating awareness among both the public and private sectors, awareness to understand the needs of persons with disabilities in all aspects of life. I thank you very much for listening.
Thank you, Mr. Danlami BASHARU, for that indeed enlightening speech of yours. Now we have Mr. Justice Zedin Zaki, former Justice of Constitutional Court of South Africa, who has shared his speech through recording. We are replaying this video for the participants and resource persons who were not present in the morning session.
Everybody, all good evening. I don't know what time this is going to be relayed. Professor Jane and all my wonderful friends in India who I know and don't know will be at the meeting. I'm sorry I cannot be there. It is a very important conference and I have agreed to answer certain questions. And my wife Anu will ask me the questions and I will answer them. So I'm not just talking.
It's sometimes said that a blind judge cannot assess witness demeanor or manage a court effectively.
Yeah, it is sometimes said, but there's a more basic problem. The more basic problem is that people think that people who have disabilities can't think. So they think a blind person can't think, a person on a wheelchair can't think. So for example, I spoke to a guy on a wheelchair yesterday, and he said to me that he asked at the shop about the price of something, and he was looking for it, and they answered his wife. And that's not blindness, that's a person on the wheelchair. And of course, all people who ask my wife, does it take you? They will not ask me, does it take you? So basically, it's a more fundamental problem. And all the other reasons, like excuses and ways. So let's get to the question of the blind people can assess witnesses. Depending on how you assess them, it is wrong to assess witnesses by how much they can shift from the witness, or how much they move around, how much, whether they reflect their noses or not, and so on. So that those are all false indicators. A poor person who comes from a deep area would be completely from a rich person. So very often, the lies are spoken by very sophisticated witnesses who have commanded the English language, who has commanded their demeanor and will do it perfectly in a suit and tie. The way to assess this is on the probability. Is what they say probable or not? Now, I've never had to discuss with this in court because I've been in the constitutional court with the assessment of witnesses who give evidence before you was not wrong. But when you cross-examine the witness, if you don't understand where the witness is, you can't cross-examine the witness properly. So the world will tell you that I was not a bad person. And that is because you exactly from their tone of voice where the weakness in the evidence lay, and I attacked it straight away. So I think that any blind judge or judge with any disability would be able to manage. Of course, a blind judge has to work hard, take longer to read the paper, take longer to do things. But if you want to do it,
how did you maintain the confidence of the bar in your mandate as a judge? Did you get lots of cynicism and pushbacks?
No, the judge had no trouble at all. Because by the time I became a judge, I had been a lawyer for 25 years. I had been a lawyer for 25 years. So they knew me as a practicing lawyer, as a practicing co-member of the bar. And I'm glad that I have a good reputation. And I do not think that anybody ever doubted that I would make a judge or not. My trouble started before when I wanted to be an attorney. Because I went to 35 lawyers looking for articles of corruption. And they all said, what a wonderful person I'm all, how much they admire me, and so on. But then they said they had no space. There was a lot of trouble getting work commission, which I had to justify. But by the time I got to the bench, the legal profession as a whole knew well, and there was no difficulty at all.
During hearings, judges are normally required to synchronously read files. How did you manage that?
Well, I had a computer, but the constitutional court was very big for me, because the accommodation was very important. I had a computer which talked to me. I had a real printer at my disposal in the court, which cost the court at that time around $2.5 million, which is a lot of money. They invested the money on me. And I read stuff in there, I was reading from the computer, I had a machine, but it did take long. And I must say that if I slept for more than 3 or 4 hours during any night when I was working at the court, it was enough. Because it does take blind people longer to read.
What's your response to those who say that a judge with a disability will create too much of complications, need too much of help, and will not be able to cope with the tasks?
I think that as a general proposition is nonsense. It depends on the judge. If the judge concerned has a disability and has learned to cope with that disability, then that's fine. So the issue is not whether the person has a disability. The issue is, has the person learned to cope with it? And if the person has learned to cope with it, then it's fine. So the inquiry is not, can a person with disability do it? Of course a person with disability can, but has a person himself or herself learned to cope with their disability? So that I think is very important.
And I think this is related to Professor Jane's final question about creating more ZACs.
Oh yes, I don't know that it is a good idea to create more ZACs. Everybody is different. Everybody is different from each other. And I'm sure that different people will have different. So you can't create it. I have been successful in history. It's been a difficult job. tried hard to learn, and I understand that people with disability will have some getting it right, but they all get more hard getting it right. It's not about brilliance, it's about hard. Thank you.
So, ladies and gentlemen, with this we come to our much-awaited moment of the day, that is valedictory speech by Honorable Justice Chandrachud. Before I hand over to Honorable Justice, let me give a brief bio of Justice Chandrachud, though he requires no introduction. Justice D.Y. Chandrachud pursued his BA with honors in economics from St. Stephen's College, New Delhi, LLB from Campus Law Center, Delhi University, obtained his master's degree and doctorate in juridical science, that is SJD, from Harvard Law School, USA, practiced law at the Supreme Court of India and Bombay High Court. Further, he was designated as senior advocate by Bombay High Court in June 1998. Sir has also served as an additional Solicitor General of India from 1998 until the appointment as a judge. He is also director of Maharashtra Judicial Academy. He has served as judge of Bombay High Court from 29 March 2000 until appointment as Chief Justice of Allahabad High Court. He served as a Chief Justice of Allahabad High Court from 31st October till 2013 until his appointment to the Supreme Court of India. Sir has been a visiting professor of comparative constitutional law at the University of Mumbai, visiting professor at Oklahoma University School of Law, USA, has delivered lectures at Australian National University Harvard Law School, Yale Law School, and the University of Witwatersrand, South Africa, has been a speaker at conferences organized by bodies of United Nations, including United Nations High Commission on Human Rights, International Labour Organization, and United Nations Environmental Program, the World Bank and Asian Development Bank. Sir was appointed as Judge of Supreme Court of India on 13th May 2016. Since Honorable Justice Chandrachud has been instrumental in authoring various groundbreaking judgments. We are indeed privileged to have your august presence for today's valedictory session, sir. May I request Honorable Justice Chandrachud to address the gathering.
Thank you. Good evening. Before I make the formal part of my presentation this evening, let me begin by saying that my presence here is a reflection of not just my association with the cause, but my personal association with two individuals who are the moving spirit of this event and who are in their own way and in their own right role models and icons, not merely for the community which is represented in this seminar, but for society at large. And these two individuals are Professor Sanjay Jain and, of course, Rahul Bajaj. I have a long association with the ILS Law College, which goes back to the times when my father was very close associate of the college, both as an alumnus and later on as the president of the ILS Society. Speaking of Rahul, I think he has been one of the chief motivators for me to be here this evening. Rahul is my judicial clerk for 2020 and 21. In fact, when he applied for the clerkship in my chambers, I was wondering what a Rhodes Scholar would want to do with something much more modest like a Supreme Court judge's chamber. But having said that, I'm delighted to have Rahul, and I can only say that my constant interaction with him has given me a new perspective and insight on problems of governance, with particularly those who are disabled face in diverse aspects of their social interaction and development. Let me just give you a brief snapshot of the fact that I chair the e-courts project for the entire country as a judge of the Supreme Court. I am the chair of the e-committee of the Supreme Court of India. And one of our missions, and a very significant aspect of our mission, is to provide technology-enabled services for the disabled, which are both friendly and inclusive. And my interaction with Rahul has been a very important source of bringing about change in terms of providing technology for access to the disabled, including the blind. Which we have done and which we have worked on, and I would like to share this with you, is about access to judgments. We have a repository in India of 3 million or 30 lakh judgments of the high courts, which are now stored on the National Judicial Data Grid, which is a repository of all judicial data in the country. A few months ago, Rahul and I were both working on this issue, and I realized, he brought it to my attention, that almost all publishing houses of judgments of the Supreme Court of India and the High Court do not provide access which would be friendly enough for blind lawyers and academicians and people in civil society who want access to the judgments. So Rahul contacted the publisher and tried at the first level to get something moving. He wasn't very successful, so I said, well, I'll take it up. I spoke to the publisher myself, and I didn't elicit any response whatsoever. In fact, my assessment was, well, this is too small a thing for the publisher to be interested in. So I took it to heart, and so did Rahul, and we thought that we must find a solution. If a private publisher or private publishers are not going to help us, well, we are not going to throw our arms up and say, well, I'm sorry, we can't do anything for this community. So what we did was the next best thing is, and that is that we have provided for a search, a judgment search online as part of the work of the E-Committee of the Supreme Court of India. And very shortly, in fact, we are going to launch our judgment search option, which would be disabled friendly, so that we as part of a national mission would be providing this facility to everyone, to every citizen, and without exception, and in a very inclusive sense. And this is a service which we would provide free of charge, because we do not generate revenue, nor are we a revenue generating arm of the state. We provide these services free. But our motto and mission is that just because we provide it free, we are not going to dilute our quality, and we're going to maintain the highest standards of service delivery. So I have to thank Rahul for this mission which we have adopted. Another small thing, small step which we took was that the website of the Supreme Court of India, the capture on the website of the Supreme Court of India was a visual capture, which meant that it was not accessible to somebody like Rahul. So when he joined me as a judicial clerk, I realized that this poses very serious barriers to accessing information. So we engaged with our team, our IT team in the Supreme Court. It took a little time, but I believe that that has been resolved by having an appropriate capture. And the next step that we are going to take before the end of this week, it's delayed to the end of this week because Rahul has been busy with this conference, which is that I'm going to write to all Chief Justices of the High Courts and identify specific issues related to technology and specific steps which can be taken by the Chief Justices of the High Court across India to ensure that access is provided to everyone in an inclusive sense. A very simple thing, watermarks on judgments which are printed across India provide a very serious barrier or a handicap to accessing legal information in the form of judgments. So these are some of the steps which we are taking as part of the E-Committee. I've been associated as a judge of the Supreme Court on the process of actually making the Rights of Persons with Disabilities Act work in practice to implement the nitty-gritties. Very often, it's not just a matter of laying down policies and broad guidelines, but actually enforcing them in practice. So one of the issues which I have been monitoring regularly is the actual identification of the 3% posts which are reserved under the Rights of Persons with Disabilities Act. So we've been pushing government departments along, ensuring that the identification process takes place, that each and every department of the government does carry out this exercise and then proceeds to implement the legislation. A very interesting issue which is pending before me. I will not speak anything about it on merits because it is pending before me. I'll only flag it for you. is the validity of the imposition of the general sales tax on mobility devices. Is that constitutional or is it not constitutional? I'm not going to speak anything about this on the merits because it's something which I will have to decide very shortly in a judicial capacity. But taking off from what Justice Yaqub said, I really begin by telling you that much of the work in this area is on confronting the disabilities of the mind of those who are not physically disabled. And I think in this process of bringing about inclusion, we have to confront the disabilities of our own minds. My mother, who was incidentally born in the 1920s, would always tell me a story when I was growing up. And she would tell me the story of how in her early years of childhood in the 1920s and 30s, people made fun of the disabled by calling them all kinds of labels in the then Thane, Mumbai and Pune area where she grew up. And one thing which she impressed upon me when I was a child is by dint of her own example and what she had seen to ensure that we as children didn't do it. And I think that really made a big impact in our mind when we were children of the age of 3 or 4 or 5, and something which has not left me. And I think it's important that all of us in our role as parents, we train our children, we speak to them, we make them understand the importance of the rights of others as we go along. So with that, let me really begin by saying that I'm delighted to be getting an opportunity to participate in this first of its kind International Summit on Legal Professionals with Disabilities. I would like to congratulate the organizers for having the vision and the foresight to conceptualize and execute a summit of this nature. The very fact that we are gathering together to discuss in an honest, constructive, and transparent fashion the challenges faced by this invisible minority within our profession, challenges that many simply refuse to acknowledge or confront, is a milestone worth celebrating. I would like particularly to acknowledge the role played by the Equal Opportunity Enabling Cell at ILS Law College, Pune, in spearheading the organization of this event. Set up on 4th January 2013, International Braille Day celebrates the practice of inclusion and seeks to foster a constructive interaction between the disabled and non-disabled students. Under the leadership of Dr. Sanjay Jain and Mr. D.P. Kendre, the cell has done commendable work in adopting a multi-pronged strategy to effectively combat the stigma and the discrimination that the disabled face. This includes organizing 5 career counseling workshops, 1 youth fest and workshop on disability and sexuality, and review of the implementation of educational schemes for disabled students. Over the last 3 days, you have engaged in a thoughtful, well-considered dialogue on how we can meaningfully confront, even if not completely eliminate, the barriers that disabled legal professionals grapple with in different areas of this profession. You have heard from such distinguished legal academics as Professor Sandra Fredman of Oxford, Professor Michael Stein of Harvard, and Professor Anna Lawson. You have heard from lawyers with disabilities at different stages of the profession, such as Senior Advocate S.K. Runta and Laura Roque, who clerked for Justice Clarence Thomas on the US Supreme Court last year and became the first female disabled person to be a law clerk in that esteemed institution. Justice Yaqub spoke a short while ago in the video about the kind of vision which you require, and does being blind detract from that vision as a judge. I can only tell you that hearing Mr. S.K. Runta in my court, I feel that he creates a whole vision of a case before you. And that vision which he sort of creates or paints before a judge is just an amazing indicator that these kinds of disabilities are really no barriers to creating a whole universe before the judge as a lawyer in terms of the arguments which you make in court. You have heard from judges with disabilities, such as Justice Richard Bernstein, who is blind and serves as a judge on the Michigan Supreme Court, and Justice Ronald Gall, who has multiple sclerosis and serves as a judge on the US Court of Appeal for the 9th Circuit. And you have heard from judges without disabilities, Justice Sikri and Justice Lokur. The theme of my presentation this evening is, while exclusion against the disabled may or may not be deliberate, inclusion must always be so. I will first offer a general account of the challenges that the disabled are forced to confront in our society even today. I will then dwell on the specific challenges that the disabled face in different avenues of the legal profession and offer some suggestions for what we can do to ensure that our profession puts into practice the values of fairness and equality that it champions and espouses. According to Martha Nussbaum, social contract theory views individuals as free, equal, and independent citizens, cooperating with each other and leading full lives. But as Kalpana Kannabiran notes in her book Tools of Justice, under this worldview, disability is a mere afterthought. She notes, and I quote her, the erection of barriers itself, however, is a matter not of volition, but of foundational exclusions, of inarticulate premises that structure consciousness and architectural design. In our Constitution, the Indian Constitution, the only explicit reference to disabilities is found in Article 41, which calls on the state to take measures for the advancement of those dealing with unemployment, old age, sickness, and disablement, and in other cases of undeserved want. The placement of disability in this list is reflective of its conceptualization as a health and welfare issue, as opposed to an understanding that locates disability within the social model. The exclusion of disability from the list of prohibited grounds under Article 15(1), an exclusion which has come in for criticism and many think needs to be consequently remedied, is also indicative of the fact that our Constitution does not, at least explicitly, give the disabled their legitimate due. This being the case, it falls on us as judges to ensure that we interpret our basic charter in such a way that its promise of full and equal citizenship, its ethos of inclusion and acceptance covers this all too forgotten minority. I began by noting that while exclusion may or may not be deliberate, inclusion must always be so. What do I actually mean by this? As a society, if we are truly committed to the project of empowering each disabled person to lead a life of equal dignity and worth, it is not enough for us to simply stop saying that discrimination against them is impermissible. That is necessary, but not sufficient. As I just said a short while ago, laying down or formulating policy instruments is important, it's significant, but that's not enough. And much of the work which we as judges do is about the nitty-gritties of implementing policies. We must equally ensure that we provide them the additional support and facilities that are necessary for them to offset the impact of their disability. Let's take the example of the 6 freedoms which are enshrined in Article 19 of the Constitution. In order for a disabled person to exercise the freedom to move freely, she requires access to accessible transport facilities, to railway stations that have ramps if she is in a wheelchair, and to braille signage if she cannot see, for instance. Without this additional support, the promise of this freedom rings hollow for her. Similarly, in order for the disabled to practice the freedom of trade and profession, under Article 19(1)(g) of the Constitution, we must ensure that we create a level playing field for disabled professionals by breaking down the attitudinal, infrastructural, and allied barriers that they face. We must also constantly challenge the stereotypes that far too many of us harbor about the disabled, equating disability with incompetence, asexuality, and an inability to contribute productively. I told you what my mother learned as a young child in the 1920s and 1930s, and the lessons that she passed on to me as a young child growing up about what we should do in terms of our approach to disability. Professor Jacobus Tenner, a notable civil rights icon in the US in the 20th century, ascribes the inability of the disabled to realize their full potential to this attitude. Noting how the disabled are viewed by society as being helpless and hopeless, he notes, and I quote him, "With the greatest goodwill in the world, they, that is the able-bodied, lead the blind man by the hands of the busy main avenues and into the sheltered back streets of society. Exclusion from the main channels of social and economic activity, and thereby the lack of opportunity for self-support. These constitute the real handicap of blindness, far surpassing its physical limitations. The absence of economic opportunity is more than the absence of economic security. It is the disintegration of the personality. It is men living out of their lives in social isolation and the atrophy of their productive powers. The curse of blindness is idleness. Idleness which confines the blind to the sidelines of life. Good players warming the bench in the game that all should play. The way in which having a disability constricts one's freedom to make one's own choices, to chart the course of one's own life, to make the mistakes that help us all grow, is evidenced by the testimony offered by Danlami, a 70-year-old physically challenged woman at a public hearing in Hyderabad in 2004. She noted that she had spent her entire life like a kite, flying where the string led her in the direction of the wind, with no space to express her will or desires. Because of the cultural conditioning that they receive, and the constant message that they are somehow inadequate and not good enough, the disabled often internalize these messages. In this regard, a renowned disability rights activist, Kenneth Jernigan, notes how the disabled sell themselves short in the following terms. They, that is the disabled, tend to see themselves as others see them. They too often accept the public view of their limitations and thus do much to make those limitations a reality. So what really happens is that they internalize the public assessment or the public perception of who they are. While the law has great potential to empower the disabled to lead full and equal lives, let us also not forget its capacity to be used as a tool to validate an unjust status quo. In my plurality opinion for the Supreme Court, for 4 out of the 9 judges, in case Puttaswamy versus Union of India, in which we declared the right to privacy as a fundamental right, I noted how some judicial decisions have to be consigned to the archives, reflective of what was, but should never have been. Foremost in this category, I noted, was the American Supreme Court's opinion in Buck versus Bell. It was a decision in which Justice Oliver Wendell Holmes, Jr., accepted the forcible sterilization by tubular ligation of Carrie Bucks, a mentally infirm woman, as part of a program of state-sponsored eugenic sterilization. Justice Holmes, while upholding the program, opined, 3 generations of imbeciles, he said, are enough. Let me now turn to the theme of this summit, the nature of the specific challenges that the disabled face in the legal profession and how we can address them. The book which I have just launched, titled It Can Be Done, the IDEA interview series, is a wonderful compilation of 21 interviews of legal professionals with disabilities. The interviewees have diverse disabilities: blindness, hearing impairment, cerebral palsy, locomotor disability, and deaf blindness. They are spread across 3 continents and 6 countries: India, the US, Canada, Israel, Ethiopia, and South Africa. I am confident that this book will make us all question our assumptions and open our minds to all the ways in which we can ensure that this profession truly celebrates the diversity and unique value that disabled legal professionals bring to the table. Speaking of my own personal experience, when I was a child, I was much weaker than the others. I couldn't do many of the things which my friends could do. I was not as robust as many of my friends. But I gradually tended to realize, and this is perhaps my shared learning over the last 6 decades of life, that nature has a unique method of compensating what it deprives. And therefore you will find that people who read these interviews will realize, within a page or two of your reading, that these are sterling individuals, individuals who've perhaps been deprived of some part of the faculties which, quote unquote, normal people have, but who have been more than compensated in terms of their vision, of their imagination, of the genius which nature has endowed to them, as this part of the balancing equation which I believe nature brings to all human life. Nature has a unique ability to balance. You look at it in the plants, you look at it in the trees, you look at it in the wildlife, and you look at it in humankind. Nature gives you in abundance what it has taken from you. And it is for the rest of society to understand that no one of us is in that sense a complete individual, if there be a definition of completeness. And it is this ability of nature to compensate what it has taken away, which really is the celebration today that this conference seeks to bring. It is also a meaningful contribution in the field of disability legal studies, a field which was introduced by Israeli scholar Sajid Moore in 2006. This field seeks to infuse a disability studies perspective into legal scholarship and practice. I will now chronicle the challenges that disabled individuals face in the main critical stages and career paths in the legal profession, while outlining the measures that we can take to make such barriers a thing of the past. The tests that serve as entry points to get into the legal profession, most notably the common law admission test, are set up in a way that does not account for the unique challenges faced by disabled test takers and places them in a disadvantageous position vis-a-vis their able-bodied counterparts. Illustratively, blind students are expected to solve questions that require visual and spatial understanding without being offered appropriate training or alternative accessible questions. And if CLAT is listening to me today, or somebody in CLAT is listening to me today, I'm sure that this is something which we need to address at the earliest, namely the exclusion which CLAT by its very design, by its architectural design, has perpetrated on the entry of the most talented students into the legal profession. The American equivalent of the CLAT, the LSAT, was challenged in court on the basis that the logic game section of the test is inaccessible to blind test takers. In a settlement which was arrived at in 2019, the Law School Admission Council agreed to do away with this section and to develop a new version of the test in 4 years that tests analytical reasoning ability in a manner accessible to the blind. The settlement stated, LSAC is committed to ensure that disabled individuals can take our exam in an accessible place and manner, that the LSAT is fair for all test takers, and that we support everyone interested in pursuing law school. For a disabled student, her challenges do not end when she gets to law school. Instead, this just marks their beginning. Many national law universities in India, what to speak of traditional law colleges, lack ramps and a barrier-free environment. Accessibility audits, vital to identify the barriers in the built environment, are rarely conducted. When it comes to securing internships and participating in law school life, the disabled must confront the prospect of having to deal with unfounded biases, lack of understanding of their actual needs, and an environment not geared up to address their needs. Let me just give you and share 2 examples. In the introduction to this book, a blind lawyer recounts the experience of being told in his internship the following by a partner at a leading law firm. those with special skills, he was told, and special skills into inverted commas. Perhaps the partner considered the word disabled too shameful to utter openly, would be better off doing a desk job as opposed to litigating. Well, I'm proud to say that this is none other than the very distinguished judicial clerk who is working with me, Rahul Bajaj. He thought that it would be very pompous to mention his name in my speech. So he had pleaded with me when he shared this with me that, well, this could be kept away. But I'm disregarding his mandate and sharing this story with all of you. So the point of the message is this: don't treat law firms, install lawyers, don't treat your duty or your allowing or permitting or enabling a blind student to work in your chambers as part of a lawyer's corporate social responsibility. It's part of the realization of rights. It's something which we owe to everybody else in society. And treat them like anybody else, and of course you have to give them the additional facilities which would be required to make them a success in the profession, but give them a chance. In her interview in the book, Soumya Sharma, who has a hearing impairment, describes her experience in the following terms. And she said, "I am reminded of the time I participated in my first ever moot court competition as a pleader in my second semester at law school. The judge kept shooting questions at me, and I stood there, confounded, not being able to understand a word of what he was saying. I wanted to assert myself there and tell the judge about my hearing problem. Yet the rules of the competition and the fact that I had to maintain professionalism there did not allow me. This got me thinking, what if I have before me a hearing impaired young lawyer who wishes to argue a case? Do we have the facilities today? And should we not have a methodology by which any hearing impaired lawyer who wishes to access the court would tell you in advance that, well, this is the case which I am going to be appearing in, so that the facilities which are already ingrained into the system and a part of the infrastructure are available for the judge to engage in a meaningful dialogue on a level platform with this hearing impaired lawyer. Many law students with disabilities report being considered as a mere afterthought, whose inclusion is contingent on band-aid ad hoc solutions. The subtext underlying the approach of many in positions of power towards them is, now that you are here, we have no choice but to accommodate you. It is unfair to place the burden of assimilation squarely on the shoulders of disabled students. Our law schools must develop mechanisms and cells like the Equal Opportunity Cell here to address the unique needs of disabled students, offer them a platform to voice their concerns and make them feel like an integral part of the community. We must ensure that those with invisible disabilities are provided the full panoply of accommodations that they require, such as extra time during examinations, rest breaks if necessary, and scribes, to name a few. In fact, taking off from here, I do believe that it is important that every court in India must set up equal opportunity cells. The Supreme Court must set it up, each High Court must set it up, so as to create an active environment for enabling disabled lawyers to pursue their professions with dignity. Because our benchmarks reflect our outcomes. This is a phrase which I use in my judgment in BK Pavitra. Because our benchmark reflect our outcomes, it is essential that existing evaluation mechanisms be updated to monitor the extent to which law schools are making a meaningful endeavor to accommodate disabled students. I note with concern that according to the revised Annual Quality Assurance Report Guidelines framed by the National Assessment and Accreditation Council in April 2020, Clause 7.1.7 solicits information about disability-related issues but leaves much to be desired. For instance, no information has been sought about conducting accessibility audits and formulating an equal opportunity policy and setting up equal opportunity units in colleges. Also absent is any reference to whether the institution is in compliance with the Rights of Persons with Disabilities Act of 2016. Let me now turn to the challenges that confront a disabled lawyer once they step out of law school. The American Supreme Court noted in the case of Tennessee versus Lane, the unequal treatment of disabled persons in the administration of judicial services has a long history and has persisted despite several legislative efforts to remedy the problem of disability discrimination. In the decision in Disabled Rights Group versus Union of India, the Supreme Court, speaking through Justice Sikri, held, a disability is only actually a disability when it prevents someone from doing what they want or need to do. A lawyer can be just as effective in a wheelchair as long as she has access to the courtroom and the legal library, as well as to whatever other places and material or equipment that are necessary for her to do her job well. Crucially, even as the court noted that there is no reason why a disabled legal professional cannot thrive in the legal profession, it equally underscored the importance of providing a disabled lawyer access to the support and resources that she needs in order to succeed. And on this front, there is much work that we still need to do. In a judgment delivered by a Supreme Court bench of which I was a part, in the case of All India Judges Association versus Union of India, we noted that all court complexes need to be made disabled friendly. They must have ramps that are operable, feasible, tried and tested, and with hand railings. For the visually challenged, we held court complexes must have tactile pavements and rail signage. Section 12(4)(b) of the Rights of Persons with Disabilities Act 2016 states as follows: the appropriate government shall take steps to ensure that the filing departments, registry, or any other office of records are supplied with necessary equipment to enable filing, storing, and referring to the documents and evidence in accessible formats. And this was what I began with when I gave you those little examples from what we are doing in the e-committee. We need to ensure that court filings become accessible to lawyers with disabilities, especially to those who are blind, for whom this still remains a major challenge. Specifically, the following measures in this regard are important, and I'll identify a few important measures. First, instead of printing and scanning their submissions, we have to get to a point where the default position entails lawyers filing PDF documents as they are prepared. The current practice of printing and scanning documents is a futile and time-consuming process that does not serve any purpose. We have to devise a practice of using digital signatures or requiring signatures only on the last page of paper books in order to ensure that lawyers do not feel compelled to print and then scan paper books because of the signature requirement. Second, I'm very happy to report to all of you that my own court, my courtroom, has adopted the above practice, making filings of written submissions 100% accessible to the blind. We have to expand this to cover all kinds of filings in all courts. Third, for documents that do need to be scanned, it must be ensured that the scan is of a high quality, with 300 dots per inch at least, and that stamps and watermarks are not placed on the page in a way that hampers smooth access. Fourth, the onus to make filings accessible cannot be placed on disabled lawyers. This would be much like serving a file to an able-bodied lawyer in a foreign language and placing the onus on them to translate it into English. Instead, we must ensure that we institutionalize systems that embed accessibility for all times to come. And fifth, instead of requiring a disabled lawyer to seek case-by-case intervention or having a separate system just for them, we have to ensure that existing filing practices are reconfigured to take account of their needs. So one of the things which I must tell you at a systemic level I'm trying to put into place is that I've requested Rahul himself and another lawyer from Mumbai to continuously engage with the National Informatics Center. And Rahul was just telling me this morning that they have now devised a meeting schedule so that every Friday they would be meeting Mr. Ashish Shiradhankar of the National Informatics Center at Pune to identify issues which they face. And so that these issues are constructively addressed not on an ad hoc or a band-aid solution basis, but by generating solutions which will be permanent for the future. And one thing which I have learned as a part of the state mechanism, and courts are part of the state system, we always pride ourselves on not being a part of government, but we are part of the wider state, the wider nation state, is the fact that once a good policy is put into place and forms a part of the infrastructure, it can be implemented for the future. So today we intend to lay down the building blocks for the future. We must also ensure that court websites become more accessible to disabled lawyers. We must remember that the mere use of digital technology will not ipso facto create a level playing field if such technology is not designed with accessibility in mind. It may actually widen the disparity between the disabled and the non-disabled, the able-bodied lawyers. Despite the clear legislative edict in the 2016 Act, sanctified in the RPWD rules to ensure full digital accessibility, several challenges still remain. For visually challenged lawyers, accessing court websites can often be like swimming with a single arm and leg. Some measures that we must take include: 1. Where visual captures are used to access any information, text-based captures must also be provided. We have already done that on the Supreme Court website thanks to Rahul's intervention. 2. I'm happy to report that the Supreme Court website now has a text-based capture. Until recently, it was not possible for the blind to independently access the website due to a visual capture. 3. Judgments and orders are sometimes inaccessible due to the placement of watermarks on each page, which must be done away. I couldn't agree with you more on watermarks, all of you, because when I see a watermark and I read with a pair of spectacles, I find it impossible to read with a watermark. And finally, court websites must have clearly labeled buttons and calendars to select dates, and that they must be accessible. In today's day and age, access to online databases is absolutely indispensable for any litigator to function effectively. The inaccessibility of any legal database for a disabled lawyer is therefore a barrier of immense import. Appropriate mechanisms need to be devised to ensure that legal databases become fully accessible to the disabled. It can be no answer for those running these databases to contend that they are far too well resourced to have to bother about disabled lawyers. But let me assure you, even if they don't bother about disabled lawyers, I believe our mission as a part of the judiciary, as part of the e-courts project, is to supplant those deficiencies by providing equal access on an inclusive footing. For the benefit of the hearing impaired, some measures to make courtrooms more accessible include having mics and speakers in halls, including conference rooms, ensuring suitable furnishing to eliminate the echo effect, and reliance on written messages or briefings in addition to oral conversations. Under the 2016 Act, every establishment is required to frame an equal opportunity policy. Section 21 mandates that all our courts need to such policies as a matter of priority and appoint accessibility officers as required by Section 23 of the 2016 Act. Further, sensitization sessions must be conducted in all courts on a regular basis to foster awareness as regards the challenges faced by disabled lawyers and staff members. Let me now turn to the bench. In his article titled The Blind Justice Paradox, Judges with Visual Impairments and the Disability Metaphor, Doran Dorfman powerfully describes the following paradox. On the one hand, blindness is treated as a metaphor for fair treatment under the law, as epitomized by Lady Justice wearing a blindfold. At the same time, blindness is widely considered a physical attribute that disqualifies individuals from becoming judges. And Justice Yaqub just proves you how wrong that stereotype is. In addition to referring to examples of several visually impaired judges who have served with distinction, Dorfman discusses at length an Israeli case that raised the question of whether an individual could continue as an arbitrator in an ongoing arbitration after she became blind. When the matter came before the Israeli Supreme Court in multiple rounds of litigation, Dorfman notes, the only judge to squarely confront the issue of the arbitrator's blindness was Justice Rubinstein. Even though the judge concluded that the arbitrator's blindness did not disqualify him, Dorfman points out how this reasoning is itself steeped in the ableist worldview. Justice Rubinstein instead framed the matter, as Dorfman puts it, as, in inverted commas, as a general act of solidarity at best, or an issue of mercy and kindness at worst. This is because Justice Rubinstein justifies the need to treat the woman with equality by drawing on the religious teaching, which is that which is hateful to you, do not do to your fellow. As Andrew Lynch and Alicia Blackham point out, it is often fairly straightforward to accommodate judges with disabilities by using hearing loops in the courtrooms, Auslan signing, electronic readers, or devices for magnification of text. However, due to the deeply embedded stereotypes, many consider this beyond the realm of possibility. To address this, the authors note that such views must be carefully examined as to whether they simply reflect the able-bodied norm of the judicial position, where any alternative accommodations for those with impairments are seen as impossible or impracticable. Resistance to reasonable accommodations should be tested for signs for a limited openness to ways in which essential judicial functions can be reconceived or recast to accommodate those with disabilities. At present, a BA and LLB course for adjudicators is being developed at the National Law University in Nagpur. Recognizing the need to embed accessibility from the inception, steps must be taken to ensure that the course content, facilities, and infrastructure are geared up from the beginning to make it inclusive for disabled students, particularly bearing in mind the requirements of access to blind students. My colleague on the committee, the Vice Chairperson, Justice R.C. Savan, has been very personally associated with the development of this course module, and this is something which I hope to take up with him. In conclusion then, my take-home message for you is this. Our approach towards the disabled must commence from the premise of inclusion rather than one of exclusion. Instead of rhetorically asking them how they can do something, we must ask them literally and with an open mind, how can they do something with appropriate support? Let me close by sharing this poem written by a blind American writer, Obadiah Milton Conover, for it speaks to the aspirations that I think dwell in the minds of every disabled person. And I'll conclude my address with this poem, short extract from the poem. And it says, alone I walk the people's city. Alone I walk the people's city, where each seems happy with his own. Alone I walk the people's city, where each seems happy with his own. Oh friends, I ask not for your pity, I walk alone. I'm really thankful to you for inviting me to make this today. And special thanks to ILS and the entire team which has organized such a beautiful event. And I hope that this will be the new beginning for some concrete policy and implementing steps across the nation to make our legal profession more inclusive, accessible, and truly an equal opportunity platform. Thank you.
Yes.
Thanks a lot, Honorable Justice Dhananjay Chandrachud, for that nuanced evaluation of the disability perspective and your suggestions and recommendations. Thanks a lot. May I now request my colleague, Dr. Deepa Patuttar, Vice Principal, ILS Law College, to deliver the vote. Thanks.
Thank you, Swati. This 3 days intellectual suite filled with deliberation, insights, and personal experiences has come to an end. This summit has been very, very different and special for all of us. Presence of more than 3 Supreme Court judges, faculty from renowned universities like Oxford and Harvard, and specially able judges of highest courts from different jurisdictions have made this discussion and dialogues during this summit very earnest, and we are confident that the world community will take appropriate note of the same. The idea of holding an international summit of disabled legal professionals itself was extremely innovative, and probably this summit is the first of its kind. We take this opportunity to thank all the stellar panelists. We were able to bring together academicians, lawyers, and judges from all parts of the world. We once again express our gratitude towards them. We offer our profuse thanks to Mr. Danlami BASHARU, Chair, United Nations Committee on the Rights of Persons with Disabilities, for delivering the keynote address. Our heartfelt thanks go to the Honorable Justice Dhananjay Chandrachud for delivering intellectually stimulating valedictory address. Thank you, sir. On behalf of the ILS Law College and all our collaborators, I thank the scientific committee for conceiving and conceptualizing the event. This event is definitely a game changer in terms of details and nitty-gritties. For the first time, we have a well-designed and dedicated website and a very rich blog of this event. Even after the conclusion of the event, the website and blog will properly preserve the imprints of the event for further interactions and deliberations. For this Herculean task, we would like to appreciate Ms. Swati Yogesh and Varsha Khandagade and Madhukar Topam sir. This trio has flawlessly taken care of every aspect of ICT for this event. I would like to place on record our special appreciation for Mr. Rahul Bajaj for helping us in drafting the concept note and prompts for the speakers of different sessions. His inputs and ideas proved extremely helpful in strengthening and enhancing the documentation of this memorable event. Huge amount of correspondence is a key to success of such online events. Hundreds of mails were exchanged with participants, keeping in mind different time zones. Timely responses to the scientific inquiries of the participants was the need of an hour, which was taken care of diligently and efficiently by Mrs. Aparna Tatke. We appreciate Mrs. Aparna Tatke for her relentless support. We also place on record our thanks to Swati Yogesh and Varsha Khandagade, Masters of Ceremony. We thank Ashish Pawar, Rohit Bokil, and Swati Kulkarni for wholehearted support throughout the summit. We thank all our colleagues for their participation and for being a wonderful audience. Our special thanks to non-teaching staff for logistic support. The dream of holding such summit could not have come true without the unconditional support of Ms. Vaijayanti Joshi, Director, Academics and Administration, and Honorary Secretary, Indian Law Society. We place on record our gratitude towards her. We also thank members of Indian Law Society for their continued encouragement for such innovative initiatives. We once again thank our collaborators, Oxford Human Rights Hub, Harvard Law School Project on Disability, Center for Disability Studies, University of Leeds, Bar and Bench, and Radio Udan, who made this event truly global. We look forward to such continued association and collaboration for future endeavors. Last but not the least, we thank the audience for their presence for all the 3 days. Thank you very much. Thanks a lot and have a good time.
Thank you so much.
Thank you. Thank you.
Yes.